Can you tell me, Your Honor, did the court grant the remedy sought by Karen Green?
No, but she obtained a declaration as to what ought to have been the action of the Director General in response to her claim. That as the Director General should have considered all circumstances of Green's claim, making such investigations as the Director General determined, and in the light of that should have decided whether Green answered the description in Section 107 and B of the Social Security Act, and whether she had satisfied the Director General as to the several matters referred to in Section 107C, and should by that means determined whether she was qualified to receive an unemployment benefit.
So what lessons can we learn about the use of administrative policy from the case?
Section 107 does not confer a general discretion upon the Director General, but lays down specific criteria, and all that is left for him to do is to decide whether or not he attains a state of satisfaction that the circumstances exist to which each of these criteria refer. Where in the course of providing guidelines to his delegates he issues instructions as to what will give rise to the requisite state of satisfaction, and these are inconsistent with the proper observance of the statutory criteria, he acts unlawfully. If his delegates observe those instructions, their conclusions concerning an applicant's compliance with the criteria will be vitiated. The question is, then, whether this general rule is no more than a permissible instruction by the Director General to those to whom he has delegated his powers under Section 107C as to how they are to determine whether they are satisfied of the matters they are referred to, or whether on the contrary it reveals an attempted substitution of inconsistent departmental criteria for those which the Parliament has enacted as appropriate to qualify an applicant for unemployment benefit.
Can you explain how the case illustrates the limited role of judicial review?
It is not for the court to decide the merits of the case. This would usurp the role of the decision-maker or the executive in the case. The court can only direct to the decision-maker that the case be determined according to the law which it states.
Following the decision of the court, how do you expect the Director General would redetermine Green's application?
What the delegate of the Director General ought to have done, had he not been distracted from his task by the requirement laid down in the manual, was to have applied his mind to the plaintiff's eligibility for unemployment benefit, testing it by reference to the criteria in Section 107C. Subparagraph 2 would have occasioned him no difficulty. It would be upon the matters referred to in subparagraphs 1 and 3 that attention would have had to be concentrated. Whether the plaintiff was unemployed, involving the question of whether she had genuinely ended her school career and was seeking a place in the workforce, and whether she had taken reasonable steps to obtain suitable work. If, on such material as she could then have placed before him, he would have been satisfied, that would then have been an end to the matter. If not, she could try again later on when she thought that she had made good the defects in her material, as, for example, by having made further efforts to seek employment. It is declarations concerning what ought to have thus been the action of the Director General in response to her claim made on the 20th of December to which I regard the plaintiff as entitled.